This case questions federal anti-discrimination rules for college sports, particularly how institutions handle eligibility for transgender athletes. The Supreme Court has declined to intervene in a case regarding transgender athletes competing in women's sports programs. For context, Title IX was enacted in 1972 as part of the Education Amendments, primarily intended to prohibit sex-based discrimination in programs receiving federal financial assistance. The court issued no explanation for refusing to hear the appeal. This inaction creates a legal environment where lower federal courts hold sway, often leading to different rulings across various U.S. Circuit Court jurisdictions. Justice Brett Kavanaugh wrote a short note along with the order. Kavanaugh indicated that the case is still pending in lower courts. Legal experts emphasize that the likelihood of success on the merits is a primary factor for the High Court when determining whether to grant a writ of certiorari. The court often waits until a case is fully decided below. This legal challenge began after a specific state policy change. States like West Virginia and Idaho have led recent legislative efforts to define sports eligibility based on biological sex, triggering subsequent constitutional challenges from civil rights organizations. The policy restricted athletes based on biological sex at birth. Supporters of the ban argued it ensures fairness in competition. Arguments centered on physiological advantages, asserting that biological male development provides athletic benefits that competitive parity and safety standards in women's sports are designed to balance. Groups challenging the law claimed it violates federal anti-discrimination rules. These federal protections are specifically defined under Title IX. Title IX ensures equal opportunities in federally funded educational programs, including sports. Plaintiffs argue that excluding transgender students creates a hostile environment, effectively barring access to the educational benefits that extracurricular collegiate sports provide to the student-athlete population. What is the biggest hurdle currently facing sports law? Lower courts have disagreed on how to read these rules. Kavanaugh noted that regional courts are still reviewing the merits. This involves reconciling conflicting interpretations of the 14th Amendment's Equal Protection Clause alongside the statutory framework mandated by Congress through the passage of Title IX decades ago. This means the Supreme Court might take the case later. Higher courts prefer to wait for clear clashes between regions. Legal scholars refer to this as a circuit split, where federal appellate courts issue contradictory rulings on identical federal questions, forcing the Supreme Court to provide final resolution. This process ensures the law is applied the same way everywhere. The decision today keeps current local rules in effect. State officials have praised the court's light touch. Meanwhile, the stakes for collegiate athletic departments remain exceptionally high as they grapple with conflicting directives between state law compliance and federal accreditation requirements for sports inclusion. Advocacy groups are already planning their next legal moves. The debate reflects broader questions about gender in public spaces. There is no firm date for a future High Court hearing. Subscribe to our channel to track this ongoing